I'm going to give my talk today in two parts. I'm going to talk about legalities and practicalities of being a board member. The legalities part, I'm going to speak from my particular occupation, vocation as a lawyer. I should warn you, I'm not giving you legal advice. I'm just telling you a little bit about how lawyers see the world and how lawyers in the law conceive an organization like the Unitarian Church of Vancouver or another church, an incorporated charity, and why that matters to the job that you're undertaking as board members. The second part, practicalities, I'm going to talk about being a board member, the role of a board member in a church such as UCV or another Unitarian church, how that works, and my own ideas, some of my own ideas about how to be a good board member, how to be a productive, helpful, constructive board member, how to deal with conflict on the board, and so on. I emphasize these are my thoughts. Not everyone would agree with them. In fact, I know of a certainty that some people don't agree with some of my ideas, but I'm going to put them out there. I'm hopeful that some of what I'm going to say is going to provoke discussion because the discussion will move matters forward. Some of these things are views, issues such as confidentiality of board meetings in which it's very possible to have different opinions, and it's a good idea to get those opinions out on the table at an early stage in your board's mandate. You're all at the beginning of this particular board, this particular community of decision makers. And it's nice to understand and have thought about collectively how you all intend to approach the role. So I'm hoping to provide some impetus to that discussion, which I'm going to recommend take place at some stage, if not today, then at a board meeting soon. Unitarian Church of Vancouver, and pretty well any church, is an incorporated entity. In our case, under the law of British Columbia, it's a society. It's incorporated under the Society Act. I want to talk about what that means, and I'm going to give you a brief historical picture of what a society is. The common law recognized, a society is a corporation. The common law recognized corporations for limited purposes. For example, the Bishop of Rochester was a corporation. What that meant was that the Bishop of Rochester could own things, say valuable paintings and artworks belonging to the bishopric. And if one bishop died or retired, the ownership would continue. The entity of the Bishop of Rochester would continue even if the current incumbent passed away and a new bishop was selected. So the original notion of an incorporation, of a corporation at common law, was simply that there was something independent of the person who occupied the role or the office, which could do certain things, could enter into contracts, could possess property, and so on. The 18th century saw the advent of corporations for the masses. Instead of having corporations created as single-shot things, well, we need to have the Bishop of Rochester, we need to have the Archbishop of Canterbury, the notion was people should be able to create corporations for their own use. Why? Well, it turned out, this is a bigger historical question, it turned out that was a terribly good way of encouraging business. It permitted public financing of businesses in innovative ways, and some people trace the development of modern capitalism through the development of the joint stock company, which is an aspect of this. But for our purpose, what it's important to understand is simply that it became possible for anybody to go and create a corporation, and the corporation would be something that had continuity, that was viewed as an entity apart from the person who had incorporated it. There was enacting legislation that made all this possible. In fact, there were two broad streams of enacting legislation. There was a business stream, which was for-profit corporations, and then there was a not-for-profit stream, which is what we're in, which was societies. Now, the for-profit stream, companies, everything from the Hudson's Bay Company down to the little tiny company that maybe somebody operates as a professional corporation, to run their little computer consulting business. Those are all on the one side. They're incorporated under a statute which in British Columbia is called the Business Corporations Act. The other side in British Columbia, as I've said, is the Societies Act. And anybody, any 2 or 3 people can get together and say, I want to form a society. I want to have a corporation that will be independent of us, but that will do things out there. Maybe run a sports team, maybe run a church, maybe run a bingo hall. So the really important point is this is a modern phenomenon. This is something that came about in modern times in the 18th and 19th and 20th centuries. And lawyers and judges, when confronted with a new thing, by legal terms, this is practically, brand new, have a problem of figuring out how to think about it, and they work by analogy. So the development of the law governing societies proceeded on the basis of 3 important analogies. Number 1, a society is a legal person. It's an entity in its own right. It's just like a person. The mind of the entity is the board of directors of the society or board of trustees. The two terms mean the same thing. So we have here something that for legal purposes is considered as a person, and you collectively are its intelligence. The second important idea was the notion of a fiduciary duty. And this is something that the law borrowed from the law of trusts. A trust involves a person who holds property, owns that property for the benefit of another person. Trusts have been around in the common law for a very long time. And the important idea that was developed there was that a trustee who owns this property as the legal owner owes a special duty of loyalty to the person for whom it is being held, the beneficiary. That duty became known as a fiduciary duty, and the essence of it was it's a duty of loyalty. The trustee is obliged to hold the beneficiary's interests first, above and ahead of the personal interests of the trustee. So that's the second idea, and the translation is you, when you are wearing your hats as directors, have an obligation to look to the best interests of the church, the entity, ahead of and in place of your own personal interests. The third important idea is simply that a society is just like a company, except that instead of having shareholders, it has members. So that idea says something about the relationship between you as directors or trustees and the members of the society. And I'll talk a little bit more about this, but the essence of the obligation is they elect you, they choose you, but they're not necessarily entitled to tell you what to do. And that's a complicated idea, and we'll talk about that a little bit. Almost all of the law that matters could be deduced from these 3 propositions. But I'm going to spell a few points out for you. First, the board, the collective intelligence of the society, is a collective entity. Individual trustees or directors have no authority on their own. When you are by yourself, you don't have any special role. You only have the ability to act on behalf of the society when you are gathered together in a meeting exercising responsibilities collectively. Secondly, officers have authority. That is, they are people who are charged with doing things for the church. Officers, the president, the vice president. But they only have authority to the extent that it's either expressly provided in the bylaws or they've been delegated that authority by the board. The board and our bylaws don't actually say very much about what the officers do. They say a little bit, but not a whole lot. Essentially, it is up to the board to decide what its president and vice president and secretary and treasurer will do. How much authority they will have, when they can act on their own, when they should come back to the board and seek guidance and direction from the board.
Since you said that that division of responsibilities isn't spelled out in the bylaws, is there some continuity from one year's board to the next?
The answer is there is continuity to the extent that the decisions of the board are set out in policy and not set out in one-off decisions. And I'm going to talk about that too. We're going to come to policy in just a second. The third thing is members of the board exercise influence through the board. This is the third idea I talked to you about a moment ago, and even a general meeting is constrained in its power to give the board direction. Now, UCB has a particular provision in its bylaws that not every church has. It's a provision that permits the members of a general meeting to pass rules that are binding on the board. But there are very few of those. I'm not sure if there are any that have actually been passed, but in principle that can occur. If that happens, it works prospectively. It doesn't work retrospectively. The general membership can't come to the board and say, we don't like that decision you made last week, we want you to turn it around. The most they could do is remove you as directors and replace you with another set of directors who might be more favorably inclined to the view of the majority. The point is, the responsibility, the decision-making responsibility is yours. And it's a personal responsibility. It's not one that you sort of take a poll on and say, oh, well, I think mood is running in this direction. You are the guys who have to actually decide things. Board members must act only in the best interests of the church. I've told you about that one. That's the consequence of the fiduciary duty. Fifth point, and you'll like this one, board members are not personally liable for acts undertaken by them as a board. It's the board's acting on behalf of the church. It's an entity. It's the entity that's acting. As an example, if you authorize the church to make a contract and the church undertakes to pay somebody some money, it's the church that has to make the payment, not you personally. You have no obligation in relation to contracts that you authorize the church to sign. You have no obligation personally, generally speaking, in relation to wrongful acts that may occur by the church. For example, if the church fails to clean its sidewalk and somebody slips and falls and sues the church, they don't have a claim against you personally because it's the church, it's not you. There are, I have to tell you, some statutory exceptions to that one. They have to do with things like environmental damage. If you create a toxic site, that you may have some personal liability there. I don't think that's likely to be a problem. Unpaid wages. These are not a practical concern where the society is solvent and insured. I'll come back to insurance. Next point, the board acts by passing resolutions. That's really the only way the board can act, which means it's very important to have a record of the board's decisions. That's why minutes are actually critical. And it's very important to actually have a process within an internal process that allows you to know when you've come to a resolution that everybody agrees to. Consensus decision-making is wonderful as long as at the end of the day it results in an agreed text. If it doesn't result in an agreed text, then you don't actually know what you've agreed to. There are two kinds of resolutions. I think of them as retail and wholesale. Retail are individual transactions. We'll enter into this contract. So-and-so will be hired or let go. Wholesale are, it is the policy of this church that we grant a cost of living increase annually at the rate of inflation, according to the Consumer Price Index, that kind of thing. That's a policy that's intended to bind future boards, or at least set a rule which will continue to be adhered to until a future board repeals it. Paul, getting back to your question, that's the answer as to what happens in terms of conferral of authority. In this particular church, there is a standing resolution that confers on the executive committee of the 4 officers authority to make decisions on the board's behalf, subject to approval by the board at the next meeting. So the executive committee has this very wide authority to do anything the board could do, but it's got to be ratified at the next board meeting. And if it's not ratified, if somebody forgets to ratify it, this decision that you've made becomes undecided, which is probably a bad thing as a rule. So be very, very careful about that. There's a compromise involved there. On the one hand, you want to give authority to a smaller group of people to make decisions on the fly if there's need, and you can't get a whole board meeting together. On the other hand, you don't want to give them authority, a plenary authority, to just run the church without having the full board deal with things. That's a compromise or a solution to that problem that came up with almost 20 years ago now, and seems to have worked because no one's changed it yet. Finally, the most important limitation on the board's authority in this particular church, and probably in most Unitarian churches, is that the board does not employ the minister. And by that I mean the board is not responsible for making decisions as to whether the minister is called, or if there's a decision to terminate the relationship with the minister. That is in fact handed over under our bylaws to the congregation at large. It's an exception to the general rule that the board hires and fires employees on behalf of the church. So you need to know about that. Now, that in a nutshell is the legalities. There's one particular legality I should talk to you about a little bit more. Supposing a board member has a personal interest in a transaction, say a contract that comes before the board. There's a procedure to deal with this. It's in our bylaws. It's required to be in our bylaws by the Societies Act, and its equivalent provisions, more or less equivalent provisions, are found in pretty well every corporation statute. This is very standard. The director, the trustee who has an interest in the transaction, let's say the director's spouse is an employee of the church and we're talking about an across-the-board pay increase, then that director might be said to have some interest in the decision. The obligation of the director is to say, when the subject comes up, I have an interest in this matter. I am disclosing my interest in it. You all need to know about that. And it is the further obligation of the director to abstain from voting. And this is very important. The disclosure of the interest and the abstention should be recorded in the minutes for legal reasons. That validates what would otherwise arguably be an invalid decision. Now there's a wrinkle. British Columbia is about to acquire a new Societies Act. The new Societies Act has been enacted but not proclaimed yet. When it comes into force, this procedure is going to change just a little bit. They've added something. The thing they've added is it will now be incumbent, when the new act comes into force, which hasn't happened yet, for the interested director to leave the room. That's not a requirement right now, but it will become a requirement. And I don't know whether it's a requirement in any other jurisdiction, but it's the sort of thing that people should look at and understand that particular process and how it works and what the limits are. And frankly, it's probably a good policy, whether or not it's a legal requirement, for the interested director to leave the room anyway. It looks better. That's my talk on legalities. So I'm going to go now, unless there are questions, to practicalities. Questions about the legalities?
You described how the executive can sometimes act in advance of ratification by the board. Does that include decisions which are, in some sense, literally executed in the time between the executive meeting and the board meeting, so signing a contract or writing a check and that sort of thing?
Yes, it does. It means that the executive committee can basically, as a practical matter, commit the church to things. You need a good relationship between your executive committee and the rest of your board. Your executive committee is probably not going to do that as a practical matter. I'm coming to practicalities. Unless they think there's a really imperative reason to do it, but it can be done. That's when I said there's a compromise involved. There's any delegation of authority involves that the person to whom you're delegating the authority may exercise it in a way that you would rather they didn't. This is what it means. And this is a practicality. A good manager, a good employer, makes expectations known and doesn't second guess in relation to the exercise of authority within those expectations.
In the case of this church, I know there's a dollar limit to the amount that the executive can approve prior to ratification by the board at a later point. But what would happen if, say, the roof blew off the church and the executive had to get together and commit something way beyond that requirement? What sort of legal situation is the executive and the board in at that point?
If, first of all, it is unusual that you wouldn't be able to get a quorum of the board together in a hurry if you absolutely had to. So this is a kind of a theoretical problem generally, and the roof hardly ever blows off. I can't remember the last time it did. But having said that, sometimes executive members, sometimes officers find themselves in a position where as a practical matter, they feel they're obliged to take steps they don't have authority for, and what happens in those cases is they exercise their best judgment and cross their fingers and hope that the board backs them up. And if the board doesn't back them up, then you have a real problem because they've acted without authority. And you need to think about that and think about just how, if it's truly an exigent circumstance and you happen to be the executive member in that position, you use your best judgment as to what needs to be done, but everyone else is likely to recognize the exigency. If everyone says, well, what else could she have done? That answers the question. But you don't want to be in that position lying awake at night wondering if your board's going to back you up. Call the board meeting instead. Or hold a straw poll. Get everyone on the phone individually. Maybe you can't have a meeting, but you can survey all except the 2 people who are in Fiji and do it that way, kind of thing. Well, I've been talking to you so far about UCV or the church as a society, as a legal entity. But of course, it's not only a legal entity. It's not only something that makes contracts and administers funds and holds property and employs staff and the minister. It is an organization involving a complex of relationships and volunteer activities. As we say weekly from the pulpit, there's a lot that goes on around here. The board cannot confine itself to narrowly legal responsibilities. It must look at its work. Much of its work has a broader aspect. And I suggest this to you, it is in this church the only volunteer body that is in a position to look at the long-term interests of the organization as a whole. Some churches have a long-term planning committee or some such thing. We do not. What the board must do is it must ensure that the legalities are tended to, because that's its primary response, that's its particular responsibility. That is budget, employees, general meeting planning, contracts. It must do all those things while at the same time stepping back and maintaining the broader perspective and understanding the work of the whole of the church, not narrowly understood. The particular challenge faced by the board is its workload. What to do and how to do it in the very, very limited time you have available. Remembering that you only really make decisions at meetings, and that the tradition in this church is to have a meeting a month, which will last, if you're lucky, 2.5 hours, if you're lucky, into the evening at the end of a work day when everybody's already tired. You're going to have to find time to deal with the big picture. You're going to have to find time to deal with things that are big problems, because it's the big problems that are your particular responsibility. If the questions were easy, they probably wouldn't find their way to you. Process. The board makes its own ground rules. it can decide how it wants to tackle problems. Preparation, however you do it, given the amount of time you have to actually meet, preparation is essential. People should come to meetings having read and thought about what the board's going to have to decide. If you do that, you'll have better meetings, more efficient, better decisions. The basic tools of procedure, motions, debate, voting, facilitate efficient decision making and the recording of the decision. I am, maybe it's because I'm a lawyer, I am a fan of those elements of procedure. You can do things in other ways if you like, but actually saying, what's the motion? The motion defines the question we're going to decide. Is there a mover? Is there a seconder? Who wants to speak for it? Who wants to speak against it? Do we have a vote? Is a very efficient way of running through business. So have a discussion amongst yourselves as to how you want to decide things and when that kind of procedure is appropriate and perhaps when it isn't. If you want to have, say, a brainstorming discussion to talk about the future of the church, that's not a who's going to move a motion discussion. That's a much different kind of discussion. Figure out when you're going to have it. Maybe you want to have a retreat on a weekend when you've got some hours and everyone's not thinking, oh my goodness, we have 7 decisions to make tonight. But be intentional about these things. Figure it out early on, figure out how you want to do it, and what it is that you're going to tackle. An important part of the board's work product is policy, the wholesale aspect of decision making. That means that all board members should be familiar with the policy that's already been established. So you're not reinventing things from the get-go. You have an established policy manual. It has all of the current policies, the ones that have not been repealed. Everybody should try to read it. Some of them are really dull. Some of them are kind of obsolete. So you should actually try, if you can, to weed out the obsolete ones. Do we really need a policy about such and such? Why do we have this? Somebody made it 35 years ago and no one remembers why? That kind of thing. But work from that. That's your starting point. That's the collective wisdom of your predecessors as to, and a good guide to the kinds of problems they thought they had experienced and thought were deserving of a collective response. Work from that. It's free, open to you to discard some of their solutions as being inappropriate to you now, but begin by knowing what they did. The second major challenge, aside from workload and definition of the things you're going to deal with, is implementation. Any decision you make, you should always address the question of how is this decision going to be implemented, because most decisions do not implement themselves. Sometimes it will be the responsibility of staff, but like most churches, we have a very limited staff and they're pretty much fully occupied already, and if you give them some big new job to do, something's going to give. You want to think about that. Sometimes implementation is the responsibility of a church committee. Better make sure you get buy-in from the volunteers you're expecting to implement the decision you've just made. If you don't, then they'll just ignore it and nothing will happen. Sometimes the responsibility is going to be assigned to a board member. If that's the case, then that should be recorded in the minutes. And someone should come back in, say, a month or two and say, how is that coming? Are we on track? Have we actually done what we said we were going to do? Remember that individual trustees don't have authority apart from that which has been assigned to them. So that's one of the reasons it's important that the minutes record so-and-so will speak to such and such, and we'll gather the information we require to make the next decision, that kind of thing. So far, this has all been easy. I'm going to get to the hard stuff now. The most difficult issues that will reach the board involve personal conflict. Inevitably, a biggish organization, there are hundreds of members and adherents. Some of them will disagree with one another. Some of those disagreements will be very, very important to the people who are involved. Some of them will be consequential in other ways. I suggest that when these decisions come to you, and they will, you ask two questions. The first, is it necessary to deal with this at a board level? Do we have to act, is this actually a board thing, or should this be dealt with at some lower level within the church? For example, if there seems to be a fight among the members of the Buildings and Grounds Committee over the responsibilities of that committee or the way it's doing something, and someone wants to bring it to the board, you may say, you know what, this is not a board problem. Sort it out down there. We'll lend you someone to help you, to help mediate the problem that appears to have evolved. Addressing a decision at the board level makes the conflict more important. As soon as you take it to the board and officially recognize it, it becomes something that's being dealt with at almost the highest level in the congregation. I say almost the highest level because there is one higher level. Someone can then decide they're going to take it to an annual meeting, and then you've got everyone in the church being asked to pick sides and come to an opinion. That's not a good thing. Avoid that if you can. The second question, or the second principle I'm going to suggest to you, is in tension with the first. The first was, do we really have to deal with this at the board? But if you decide that you do, if it's necessary to deal with it, I suggest to you the board should not be afraid to exercise its authority and take steps to resolve the conflict. Now, Unitarians tend to be authority averse. They tend to dislike the idea of authority, many of them, and the idea that there's some discomfort with the idea that the board would tell anybody what to do. So I just ask you to bear in mind, sometimes, forgive me for saying this, sometimes people need to be told. As between John and Harriet, Harriet is right, John is wrong, John should stop talking about this. The board supports Harriet. There are problems that can be made to go away if a decision is made, which will not go away if the dispute between John and Harriet is simply permitted to fester, and they continue niggling at one another and nobody actually decides. It is your responsibility, sometimes, not often, to do that, because you're the people who are in a position to do that. You actually do have authority. The question is whether you choose to exercise it. I want to talk about board solidarity. This can be a really vexing problem because different people will have different assumptions about what should happen. And I'm raising this really in the hope that you will have a discussion amongst yourselves as to what your collective expectations are. There are views out there. I'll give you two extreme views. On one side, there's a kind of an extreme view that says, I'm a solitary individual decision maker and nobody tells me what to do or say. On the other extreme, there's we are a collective enterprise, the board, and we should all march together and honor the group decisions making process and not ever criticize anything that's been decided by the board. Those two views cannot coexist happily. So I'm going to offer some thoughts for what it's worth. The first is, no one is ever under an obligation to agree with the others. Your fellows on the board may, a majority of them may believe that such and such is the right decision and you may disagree, and the fact that you're in the minority and they're in the majority does not mean that you're under an obligation to go along with them and say, yes, I agree. You are permitted to say, you know what, I've been outvoted, but I don't agree with that decision. You are never under an obligation to say that you agreed with a decision that you did not agree with. Being a board member doesn't mean you're obliged to fib. You are, in my view, under an obligation to explain to non-board members what the board has decided and why it was decided, even if you didn't agree with the decision. You have that obligation. Members of the church are entitled to know what's going on, and you've got to be fair to your fellow board members. I've left unresolved a question that goes beyond that as to how far, whether there's any obligation to support a decision with which you did not agree, going beyond this is what was decided and I personally didn't agree with it, whether there's any obligation there. But you'll see from the way I've framed it that it's really quite a nuanced question. This won't generally arise unless you've got conflict on the board. You should have a level of disagreement on the board. It's healthy. People bring independent minds and views and perspectives to things, and the questions are difficult questions, and I'm very surprised if a whole bunch of independently minded people all come to the same view on difficult questions. That seems odd to me. There's something weird happening if that happens. But there's a difference between that and a kind of sustained conflict where people start disagreeing with one another on principle. And one hopes that doesn't happen. If it starts to happen, you should take some steps to try and see if you can make sure that it's not a personal conflict, that it's a truly idea-based conflict. Conflict that is taken out of the board, the conflict, disagreement within the board's fine, but if it goes out of the board, it becomes an issue for the congregation. And I want to suggest to you that absent extraordinary circumstances or profound issues of policy, it shouldn't be necessary. You should not have to do that. It should never be necessary if the dispute is essentially a personal dispute. So if you find yourself disagreeing and you're wanting to chat with people outside the board about your disagreement, sit down with yourself and talk to yourself first about what's really going on here. And then talk to the person you're disagreeing with about what's really going on here, if you can bring yourself to do it. And talk to someone else, probably the president, about what's really going on here. Try and deal with it in that way. Confidentiality and privacy. There's a tension here, and it arises in this way. On the one hand, members of the congregation really have an expectation, and I would say the right to know what's going on with their organization. There should be openness. On the other hand, the board will have to deal with matters which are essentially personal and private. And those matters really, that privacy shouldn't be lost simply because someone's private matters happen to be the subject of discussion at the board. I'll give you a couple of examples of personal and private information just to make this concrete. People give money to the church. That is generally a very personal decision as to how much people are giving. In our church, it would be startling and upsetting for people to find that their donations had been posted in a public place, so that the amounts that individuals had given, the 10 biggest donors and the 10 smallest donors, were all there to be seen. That would upset people tremendously. That's considered private information. And in my experience within this church, it's always been treated as such. The treasurer knows, because the treasurer signs tax receipts. The head of the canvass committee knows, or probably some other people know. It has never been discussed at a meeting that I have attended, who are the biggest donors and so on and so forth. The sensitivity is appreciated. In our day and age, matters such as telephone numbers, addresses, the details of what people earn, personnel files of employees of the church, those are all matters which have some degree of privacy associated with them, in addition to which we have legal obligations to maintain the privacy of records pertaining to people where they have a reasonable expectation of privacy. So there's the tension. You're going to have to work through as you deal with stuff. Here are my suggestions, and this is largely taken out of what I understand to be the established practice and the long-standing established practice of the board. The first is this: board meetings are open unless the board goes in camera. That's how this church does it. Secondly, the board goes in camera to discuss personnel matters. When it goes in camera, non-board members leave, except generally the minister. The minister stays unless the matter concerns the minister, in which case the minister will leave. The problem is not generally with a whole bunch of people showing up at board meetings. The problem is generally trying to make sure that people know what the board was going on. You'd love people to show up, but they would just show up. Please show up. Come to the meetings. If you go in camera, the minutes will not record the discussion, but the minutes must record any resolutions that are passed. Because if the resolution isn't recorded in the minutes, it's not really a resolution. The board acts through resolutions. And members of the church have a right under our bylaws to see board minutes. They have a right to see the records, including, by the way, the financial records of the church. So we kind of navigate through what we have here, and we try to do it in a way which is respectful of people's expectations and which is also respectful of the essential need for transparency in the operation of this, which, this end where I began, is an enterprise that we are carrying on behalf of the congregation as a whole, not for ourselves, but for the larger group. Yeah.
I was wondering who is responsible for hiring and firing personnel. Would that be the office administrator, like to, interview people, or is it the board? Or
I'm going to get Patty to answer that question in part, but I'll just begin with this. There's a personnel committee. The board has delegated a lot of personnel stuff to the personnel committee. At least that's been the past pattern of practice. The second part of the answer is it depends on the employee. For example, there are casual employees in the RE department who I think are probably hired by the DRE. Am I right about that, Patty? I'm right about that. There are caretakers who tend to be hired, I think, generally by the office administrator. Yeah. We have some positions are hired directly by the personnel committee. It very much depends. I've been on other boards. I found this board to be the most satisfying board I worked on. I also found it to be the most challenging board in some respects, not in a bad way. The thing that I found both challenging and deeply satisfying was that we would deal with very difficult problems, and for me the most difficult problems were always ones that had a personnel aspect to that, or a personal aspect. They tended to be intractable issues, and they would come before us and we'd wrestle with them. That there'd be someone who was just plainly a difficult person, and we're dealing with this difficult person, and something had to be done in order to resolve the problem. And the decision would be made. And then someone would say, what are we going to do to help so-and-so? How are we going to, we'll do what we have to do, but we need as well to remember who we are and why we're here, and the broader ambition and challenge of this as a religious and spiritual and ultimately caring institution. And my experience was that was always present. That particular piece of this work was always present. And I developed an immense respect for my fellow Unitarians through being on the board. I suspect you will as well. It is an interesting job. I commend you for having taken it on. It is a challenging job. It is a worthwhile job and an important job. And I wish you all the best in it and the best with it. Good luck.
I know this is a little bit controversial, but committees will get out there and say they're representing the church, the Unitarian Church of Vancouver. It's a slightly different concept because the Unitarian Church of Vancouver is an entity that has to be protected. A Unitarian can do anything they want, and we do often.
Committees will get out there and they won't even realize what they're doing.
Well, that's why sponsorship has to go through the board.
Yeah.
And that's something that we've been encouraging a lot this last year, is that if you're going to sponsor an event or put our name on something or to carry a banner, then it has to be approved by the board. And that's a tricky one, because people do feel like they have the right to carry a sign and not get our approval. But I think that it's incumbent upon us as the board to instill the importance of that into our members, because really at the end of the day it is representing all of us and not just the committee.
Someone says, I know, you can donate the money to the church and we can give you a tax deduction. No. And it sounds like just a wonderful idea for, look, we can get all this money and we'll give tax deductions and then we can cause our cause. And that they think, because they're identifying with the church, and there's no problem with the church. I give money to the church, I get a tax deduction, you can give money to the church and get a tax deduction, and we'll use it for X. In the middle of that process, they are getting us into the glue in a big way.
Oh, this is really important.
The ability to give tax receipts does not belong to committees. It's a church function. And just to be, lest people think the government is being terribly heavy-handed here, when you give a tax receipt, it's the equivalent of writing a check to somebody from government funds. That's what it is. So CRA, lots of us disagree with CRA about lots of things, but CRA is not being wholly unreasonable when CRA says, wait a minute now, we want to have some checks, some auditing on the giving away of tax receipts. It is from a public policy point of view, a perfectly reasonable thing for CRA to want to do.
We're happy to give tax receipts when people give money to the church, and they don't have any other, motivation behind it. They're not trying to slide money under the table to another organization. Sure, give us all the money you want, and we will give tax receipts. That's fair enough.
Oh yeah. You said about decision making at the board level, that motions get made, discussed, and passed, and there's no obligation for there to be a consensus on those decisions. But I have seen quite a few boards try to reach consensus. And there's some boards use cards to signal their degree of support for a motion, and so there'd be a green card by people who support a motion, a yellow card if they're not sure or they can support it with reservations, and a red card will stop the motion for discussion, or if they've decided they want to reach consensus on decisions, it'll stop that decision. And then what happens is there are questions to that person like, well, why? Is there anything we could do that's kind of part way toward the decision that could get a consensus of the board? And sometimes you get better decisions. You certainly get better buy-in when you're able to go through that kind of process. And I've seen people be very, very thoughtful about one person who stands, like 12 Angry Men, where one person stands out and you listen to them for a while and you think, okay, I see their problem. A certain level of compassion is generated, I think, through that attempt to reach consensus. So sometimes it's useful, but I would agree sometimes you just need to bite the bullet and have a disagreement happening.
No doubt it's because I'm a lawyer, but I am a believer in debate. Debate clarifies things, and debate very often works because it niggles at whatever the problem is and reveals often that the problem is a more complicated problem than it may have originally seemed, and sometimes reveals that there's middle ground or space for a solution that's satisfactory to everyone. I would never say that you shouldn't struggle to reach that. I do think that that there's some consensus, so consensus is a valuable thing. It just shouldn't be an end in itself, in my mind. At the end of the day, there will be disagreement. You shouldn't try to pretend that all disagreement can be resolved. It's not really possible. And the effort can sometimes be just, the phrase is a time suck. You can spend a really long time trying to assuage the concerns of a single person. And at a certain stage, everybody has to move on because you're hijacking the decision-making process to try and deal with this thing here, and there are other things that need to be addressed as well. But that's not to say that anybody should be running roughshod over anybody. It's a question of dealing in a respectful and appropriate way with the problem at hand.
I think one thing that's greatly to be avoided is taking a grudge from the out of the board meeting to the congregation in general. That would be like the epitome of bad behavior for a board member. Yeah, is it?
I think, well, I said something about that earlier. I think it should not be necessary unless what you've actually found, the disagreement, is one that raises a profound issue for the future of the church kind of thing. There are circumstances where I can imagine somebody saying, I have no choice, I must take this to the congregational meeting. I just don't think that those circumstances arise more than once in a generation, if that.
Right. No, I wasn't thinking of the congregational meeting. It was more kvetching.
Oh, kvetching shouldn't occur. I agree with you. I think it's bad manners. That's one way to think of it. It's just bad manners to be complaining about these people that you're working with every day in a kind of a public way. It's not going to improve your relationship with them, I can tell you that. But
we do have, many of these things we have worked through in the last 100 years of the church. And for example, we do have a policy of right relations and things like that give us some goalposts or some roadmap of, in fact, how to try to structure things that, for example, conflicts of personalities and things like that are usually the kinds of things that will result in exactly what you just described.
Right.
And there is a policy for conflict resolution as well. I mean, a step-by-step policy, and we tend to forget that exists and that we should actually follow our own policies.
I'll give you one that happens, or can happen. This is all hypothetical, by the way. Just purely hypothetical, understand. Let's say there's a staff person who's having trouble getting on with his or her superior. And the staff person is talking a lot to friends, supporters within the congregation. And the superior is talking to the personnel committee, and the personnel committee is talking to the board, and a decision is being arrived at slowly that something's going to have to be done. This is not a healthy working employment relationship. Something's going to have to be done. And the staff person who doesn't want to lose his or her job starts saying to his or her supporters, I think they're working to fire me. And his or her supporters say, this is outrageous. We're going to the mat. And the next thing they know, you're going to have questions being asked at a general meeting, at a congregational meeting, about why are we treating so-and-so so badly? And at that stage, if you've gotten to that place, everyone goes, oh my goodness. Are we really going to proceed to disclose in this forum the entire history of the attempts to resolve the problems with this particular staff member, the entire history of the discussions at Personnel Committee with the superior, who, by the way, is feeling very vulnerable right now because there's an implicit struggle here. And you want to do whatever you can to keep that particular debate discussion from coming before a congregational meeting. It cannot end well. There is no good, if it gets to that place, there is no good process that is going to make everybody feel really good about and happy about what we've just done. So you try and get personnel decisions out of the congregational meeting. In fact, you try to get them out of the board, you try and get them into the Personnel Committee. That's what the Personnel Committee is for, in large part. And if people do start standing up at general meetings and saying, well, I want to know why we're treating so-and-so, someone, probably the president, stands up and says, you know, it's our policy not to discuss personnel matters at general meetings. We don't do that. I don't think that's a good idea. And if you get wind of that one coming down in advance of the general meeting, board members go to the people who are complaining and say, you know, this is not a good thing. We would really like it if you don't do this. Happy to talk to you privately maybe, or maybe we can't talk about it privately, but this should not be discussed in this way. Now, the congregation as a whole is fairly savvy about this sort of thing. The congregation as a whole will mostly not insist on having that discussion at a general meeting. But this, while this is wholly hypothetical, of course, this kind of thing does happen from time to time. And you really want it not to happen. You really want to try and manage the process in a way that causes it not to happen, because it's not good for the church, it's not good for the individuals involved, it's not good for anybody. And there is no good way to discuss the deficiencies in someone's employment in their employment performance in front of a group of 150 people. It cannot be done. All you will do is hurt feelings in a way that has to be seen to be believed.
If you were telling us about the ways that a lawyer as part of our congregation could perhaps sometimes be helpful, I'm just thinking, because other people across the country are hearing this, would it be your advice that newer or smaller congregations find someone to be a legal consultant?
It's probably always helpful to a congregation to have someone they can go to for legal advice. They're always going to want to do it for free. It's great, you know. I'm enough of a professional to think that lawyers give valuable advice, so people should, in fact, recognize that there's important stuff out there that they need to know. Having said that, you can't count on getting free legal advice. Legal advice is expensive. If you can find a member of the congregation who will give you free legal advice from time to time, I think that's great, but you should be willing to pay something for basic advice. The kinds of basic advice that I would think any congregation should have is they should have some understanding of how their incorporating statute works, what their obligations are annually to make sure that they maintain corporate registration, what the ground rules are for maintaining their charitable tax status. Their accountants may be able to help them with that as much as lawyers. And if they're entering into long-term financial commitments, if they're buying property, they need a lawyer. If they're selling property, they should probably have a lawyer to make sure they end up with money at the end of it. If they're entering into a mortgage, all the transactions that a person would hire a lawyer for, probably the congregation should be willing to hire a lawyer for and should accept that it's going to be expensive.